Thank you for coming, everybody. It's delightful to see you all. I feel like I know almost all of you intimately, and it's great to have this kind of support. So today we're going to be talking about the probate court system. I founded Trust Document Service back in 1990, and so I've been doing this for 25 years. I just found myself in love with this subject, okay? I originally got involved in it because I was interested in doing irrevocable trusts and asset protection, all that. But over the years, pretty early, I shifted over to revocable living trusts because I saw how it was really, really important to everybody, not just a few people that wanted to protect their assets, but it was something that was important for everybody. When I sit down with my clients, I go through a four-step process. The first step is I talk about the history of the courts. You know, how the courts work and why they work that way. And I'll actually be showing you court documents, so you won't have to just take my word for it. You can see what's going on. The second thing I do then is I talk about our documents. And I go through each document and explain why each section is important in avoiding the big gorilla in the room, which is probate court. The third thing I do then is I ask about your assets. So I'm not trying to see how much money you have or anything like that. What I'm trying to figure out is how much time it's going to take us to put together your documents. As soon as I have that figured out, I'll say, okay, John and Mary, we can do your documents for, and I will give you a set price. Okay, that price will pay for everything. There'll be no hidden fees at all. So if at that point you see definitely want to avoid probate, don't want anything to do with that, you like our documents, be proud to own them. You like me, feel like you could work with me. The price fits your budget. If all that stuff comes together and you say, Philip, we'd like to go ahead, then we get into the fourth step, which is where we start gathering the information from you to put together your living trust documents. You've heard of a will. When you draft a will, you say, okay, if something happens to me, I want my son, my daughter, my best friend, whoever, to take care of things, and this is what I want them to do. And what people think is that when they draft a will, their son and daughter is going to be able to take this and go do this stuff. What they don't realize is what you're actually doing is you're saying, Madam Judge or Mr. Judge, will you please take care of this? You're actually asking to go to court. Furthermore, without realizing it, you're saying, and Your Honor, I have suggested that you use my son, my daughter, my best friend, whoever. But if you have somebody you'd rather work with, I understand. Furthermore, without realizing it, you're saying, and Your Honor, I have suggested how I want my stuff distributed, but if you have a better plan, go right ahead, because you're in charge. And people say, what? This is my stuff. I should be able to distribute this any way I want. And I say, couldn't agree with you more. Unfortunately, you've used a document that always goes to court. And people say, well, what difference does that make? Well, to understand that, we ought to go through the history of the court system. When you think back through time, what's the earliest time you can remember them referring to the word court? People think about it, and somebody says, I know, King Arthur. King Arthur in his court, he had a court. King David, King Solomon had courts. What a court is, or was, and still is a place where you would go talk to the king. Now, why did you do that? Well, one of two situations was present. One is where the king literally owned everything and everybody in the whole kingdom. Everything was his personal property. The other situation is where the king didn't own everything, but the king was the most powerful political person in that area. And if you're going to be doing anything in that kingdom, you better run it by the king, either because it's his property you're fooling with, or you just want to make sure you don't accidentally offend him. In either case, whatever the king decides is absolutely the way it is. Okay? The king has absolute authority over everything, including life and death. The most dramatic example of that is, if you remember back in the Bible, when these two women were arguing over whose baby boy it was. Remember that story? Okay. And the king said, well, just cut the baby in half. Well, the real mother screamed and said, oh no, give it to the other woman, trying to save her son's life. King was smart. It was King Solomon. He was smart. He knew exactly who the mother was. My question is, why did she scream? Why did she look at him and say, cut him in half? Are you kidding? Oh no, she didn't do that. Because she knew the king had absolute authority over everything, including life and death. And if he told the soldier to cut the baby in half, the soldier cut him in half. Because that was the power and authority the king had. Okay? Now, you fast forward to today, and when you walk into a courtroom, what you're walking into is a one-room kingdom where that person up in front has absolute authority in that room. Of course, that person up in front is passing judgment, so we call that person a judge. Now, I have a friend of mine, and he's sitting here today, who had a case in San Jose. And he went before the judge, and he said, Your Honor, this is what the law says. Completely supported my friend's position. The judge looked right at him and said, I don't care what the law says. I'm going to rule this way. And ruled exactly opposite of what the law says. And people say, what? The judge doesn't follow the law? And I said, you don't understand. In this room, the judge is the law. Now think about it. If you have a judge that rules against you, what can you do? What can you do? You can appeal. Okay, to whom do you appeal? Another judge in another courtroom, right? Okay, if you don't like what they say, what can you do? Keep on appealing all the way up to the Supreme Court, where there are 9. Actually, they call them justices. And I have yet to find out anybody that can tell me why they call them justices, other than I think they just wanted to be different. That's the way it is. Okay, if you don't like what the Supreme Court says, what can you do? Nothing. You can't call your congressman, you can't call your senator, you can't call the President of the United States. Because think about it, when you reach the end of the kings, that's it. Nobody can overrule a king except for another king. Truth is, if you say, you know, I want my kids to take care of things for me, judge is probably going to say, fine, it's not my problem, I can work with them. And if you want your stuff distributed such and such a way, the judge is going to say, not my stuff, I don't care. But if somebody doesn't like what you've done, what you've said, they can go hire an attorney and go to court and make an argument. And if the judge says, you know what, you're right, I'm going to change things. What would have just happened, you might have heard this phrase before, what would have just happened is they broke the will. That's what it means to break the will. Now, chances are the judge is going to say, fine, you want these people? Okay, you want to distribute it this way? Fine. But what you expect is that your son or daughter or your best friend or whoever is going to be able to take this and I'll go do this stuff. Guess what? They can't do that because this document has no legal muscle. What they're going to have to take with them are the judge's orders because the judge is the one with legal muscle. Okay, what does that look like? Here is a case in Fresno County involving a guy named Lionel. And we see here, see if I can get closer on this, that the amount of the estate is $115,329.57. Not a big estate by today's standards. First line is expenses of administration. That says statutory commissions. What does that mean? Well, statutory, by state law, by state statute, by state law, You've heard, okay, that's what the first word is. The second word is commissions. Well, you've heard of an executor. An executor gets paid, and the executor's pay is called a commission. So by law, the executor gets paid $7,158.04. Well, come on, 4 cents. Why don't they round it off to the next dollar or something? Well, that's because by law, it's a percentage of this, and they follow the law to the penny. Next line, statutory attorney's fees, $7,158.04. Same amount. Interesting. Next line, extraordinary commissions. Oh, the executor did a little extra work, $500. Extraordinary attorney's fees, $5,330. You add that up and it comes to $20,146.08 that did not go to the heirs. That's a pretty big bite out of that. And I'll bet you Lionel would have rolled over in his grave 3 times if he had known that was going to happen. Is there a better way? Of course. That's why we're here. You've heard of a living trust. You draft a living trust and you say, okay, if something happens to me, I want my son, my daughter, my best friend to take care of everything, and this is what I want them to do. Here's the difference. Something happened to you. So a plane goes down, you and your spouse, if you're married, are wiped out. And let's say your daughter's taking everything. Your daughter can take this document and can go to the bank, can go to the real estate office, can go to the stockbrokers and say, this is my parents' living trust, here's their names, here's their death certificate, here's my name, here's my driver's license. They'll look at all this stuff and they'll say, okay, what is it you'd like to do? Why is that? That's because this document has legal muscle. Does it work?